start record. And I will admit those that are all waiting. Welcome, everybody. Everybody's going to start. There's still some people coming in, so we'll start in just about a few minutes here. Make sure everybody's on mute, if you could, please. All right. I think there's more people coming in the waiting room, letting them in. Awesome. Welcome, everybody. We appreciate you being here today. This is SLA Industry Updates. I want to thank everybody for being here. I also want to thank today's presenting sponsor, which is Bellmark, and our session sponsors, which are Hillebrand Beer Supply, Chain and Keg Management Specialists, and Tri-State Carbonation. So we appreciate them. And I appreciate the folks that are going to be with us today. I want to thank Chairman Vince Bradley, who's been Chairman of the State Liquor Authority since 2015, for joining us. Tom Donahue, who is also a lead attorney and secretary to the authority. Sharif Kabir, executive deputy commissioner, and one-stop shop. And before we hand it off to Tom, who's going to start things with some updates, I just want to let everybody know that, it was almost a year ago when everything, hit the fan. And before it hit the fan, I heard from the State Liquor Authority, and I believe it was Sharif, kind of asking what our industry is going to need. And I can't emphasize enough how lucky we are in New York State to have a State Liquor Authority that is an ally. They obviously have a job to do in making sure that regulations are followed and rules are set in place. But I can tell you that they have been really responsive when needed. And we also have Stefan Fleming here, our one-stop shop, and Stefan really helps us a lot when we have questions, regulatory questions with the authority. So I could go on and on about how great the authority is and how lucky we are. So thank you all again, Chairman. Thank you, Tom, Sharif, and Stefan also for being a part of this call today.
And Paul, I just want to thank you for having us. Every year you invite us to this, and it's a great way for us to hear from the industry as well as to let you all know what we've been doing. And you're a tremendous ally, and I think you're a great representative for your industry, as you've shown throughout this whole pandemic.
Well, thanks, Chairman. And so, Tom, I want to start with you, just as a general update on what's going on right now, and anything you can kind of tell everybody to give them some updates on what's happening.
Well, what I'll do is, since we missed last year, I'm just going to go through some legislative and administrative updates for the past 2 years. I'm not going to touch on any of the COVID stuff right now, but just, as I said, the more generic changes. So legislatively, we may have discussed this back in the 2019 session, but there was the farm media law that came in late 2018 that impacted brewer licenses. After that, we had starting in 2019 the state fair permit. To address some of the problems and confusion about who can do what at the state fair. So there's now a permit to sell alcoholic beverages at the state fair. Brewers, microbrewers, farm brewers do not need it if they're just selling their own products, the things they could sell otherwise, as long as they have a concession permit from the state fair. If you want to do anything else, you have to get the permit. Also in 2019 and then modified somewhat in 2020 were changes to the restaurant brewer license. I'm not going to go into great detail about that. But for those of you who are restaurant brewers, you're not aware of the changes, you should take a look at that. There were also changes first in 2019 and then again in 2020 regarding real sales taxes on beer tastings. The one thing I want to point out is that although these two provisions made changes to the ABC law, they really have nothing to do with the ABC law, right? Or particularly, whether or not something is or isn't a tasting or is a sale by the glass under the ABC law. This is, the provisions are strictly related to whether or not a transaction is exempt from sales tax. So while they're snuck into the ABC law, they really have nothing to do with the SLA, and it's really a matter between the brewers and tax and finance. Next, also in 2019 and modified again in 2020, was changes to the terms of sale provisions. Used to be you had to pay your bills to your wholesalers. I mean, that retailers, that is, by retailers paying their wholesalers either by cash or check or electronic funds transfer. Now there is a provision to allow for essentially credit card payments. The initial law was going to have the authority set the processing fee, so to speak. That's been changed. It's now 3%, but there is a provision now that allows, and it's optional to the wholesalers, don't have to do it, but it allows retailers to pay their bills by credit card. There wasn't much legislation at all, new legislation in 2020 for obvious reasons. One thing that did came out, not particularly relevant to you, but I'll mention it anyway, was a change in the frozen dessert ice cream provisions. It had been for years that frozen desserts and ice cream made with wine were not considered alcoholic beverages. That was changed a few years ago to add beer, and now it's also liquor. There are a number of conditions attached to that, how it's sold, but you don't need a license to sell it if you meet those conditions. As far as advisories or declaratory rulings, other than the multiple COVID advisories that we've issued, the only recent guidance that's been issued that's arguably relevant to the brewers is there was a declaratory ruling back in 2019 at the request of a distiller who was asking about whether or not New York liquor he was making that was being shipped out of state for some finishing and blending, and then came back, would still be considered a New York State liquor as long as the ingredient requirement was met. And the board said, of course it would. So, for those of you who are farm brewers or brewers making New York State labeled beer, and you've got maybe an out-of-state brewer working with you to involve somehow in the production process, just keep in mind that the key part is whether or not you meet the ingredient requirement and not so much where the product is being manufactured. So that's really about it. There hasn't been all that much, other than the COVID actions that have taken place. I think now, Chairman, you want me to head down there, Chairman?
Sure.
Okay.
So I just kind of wanted to generally summarize some of the stuff, because as Paul pointed out, we're almost, next week it'll be exactly a year since this was, the state was shut down. And I kind of just wanted to go through some of the stuff that we've done, hopefully to try to keep not just the manufacturers' heads above water, but also our bars and restaurants. I think the most important thing that happened initially when the state was shut down was that the governor, through an executive order, deemed manufacturers essential businesses. And I know Paul, along with a lot of other people, lobbied hard for that to happen. And the importance of that was it allowed you guys to stay open and sell beer to go, and then eventually sell it for delivery as well if you had a on-premise license. I still, to this day, remember the phone call I got from the governor directly, which doesn't happen as much as you would think. And that was in early, the pretty much the date that he shut the state down, and I was in my car, and he told me he was shutting the state down, but he wanted to keep the bars and restaurants and manufacturers open, for to go, which I thought was a good idea. And then out of the blue, he mentioned that he wanted them to be able to do to go alcohol, which, to be honest with you, is never something that has been discussed in this agency. So we had absolutely no idea how that would look or what it would look like. And we were required to put that all together by 5 o'clock that day. I think Paul, who deals with government regularly, can tell you that just getting a law like that passed, along with all the restrictions that would come along with it and the obligations, would probably take upwards of a year or more. And I think it's a testament to the guys that work here and girls. Sharif Kabir, who's the executive deputy commissioner, put together guidance really in a matter of 6 hours that has now been used as a model, I think, throughout the country. And we all had input and we all went over it. And by 5 o'clock, there was guidance for takeout alcohol for not just the restaurants and the bars, but also the brewers as well, and other manufacturers that had that type of operation. So that was probably the most important thing we did initially, and it really had a great deal of effect, because it allowed these businesses to stay open. And while they're all suffering, I know how much you guys are all suffering, and the bars and restaurants are all getting hurt as well. Hopefully we can get them through this to where we can be back at 100%, and that we don't lose as many businesses as we certainly would have had everyone been required to be shut for that entire period of time. Some of the other stuff that we did on March 31st, the board extended the time that licensees could pay the renewal fees. We extended it. It's now extended until March 31st of this year. That probably will be extended again because it's been extended pretty much for a year at this point. We also back then extended the time to allow licensees to pay their civil penalties. So while we certainly still write violations and do what we were always doing as far as following up on complaints and making charges, when those charges settle or when the charges are proven, the penalties have all been deferred, and they're still deferred. We do continue to impose cancellations and revocations, obviously, because that's an issue for safety and public welfare, but all other penalties have been deferred. We also, during this period of time, lowered the wholesale price. We allowed the wholesalers to lower the prices for retailers for a period of time. We allowed email notifications from municipal and community boards. We extended the time frame for license applications to answer deficiencies and for fingerprinting. And last April 15th, we approved an advisory allowing beer manufacturers and wholesalers the freedom to adjust prices from March 15th of last year to May 1st, because obviously the pandemic was unexpected and a lot of licensees had stocked up on beer that they now realized they were never going to be able to use. So that they were able to we allowed returns, but we also allowed a price decrease. And on June 4th, when restaurants and breweries and other manufacturers started to be allowed to reopen around the state, we created a process that allowed for the expansion of the licensed premises. For anyone who has actually applied to expand their licensed premise in the past, it's a relatively onerous process, and it takes a significant amount of time. What we did was pretty much eliminate that entire process due to the pandemic. If the area that you wanted to license that was outside was contiguous to your licensed premise, you were allowed to use it immediately. And all you had to do was send us a diagram within 5 days and indicate that that was the area you were using. You were allowed to use it immediately, as I said. So the diagram, as long as it came in within a week, was all that was required. Additionally, we allowed licensees to use areas that were not contiguous as long as the municipalities approved the use of those areas, as long as they were directly in front or to the side of the licensed premise. We are most of those changes or the things that we did to try to help the businesses through the pandemic came from the industries themselves, whether it be from the restaurants or bars, or in this case from manufacturers. And that's why these relationships to us are so important, because we don't know what's needed, particularly in the specialized areas, and especially during a situation like this where no one can predict what the next thing is going to bring. So our relationships with your industry, as well as with other manufacturers and the hospitality industry, have been crucial throughout this whole thing, because a lot of the action that we took, as I said, was in consultation with the industries themselves. One of the things we are doing, we did propose this year to try to help businesses once this pandemic is over, is we got the governor, I should say, put a temporary license for manufacturers in this year's budget. Hopefully that will expedite the opening of new craft manufacturers across the state. Governor Cuomo proposed a new permit to allow the manufacturing businesses statewide to begin operating while their liquor license applications are pending with the State Liquor Authority. It's currently available to business applying for the farm winery license, but it will be expanded hopefully in this year's budget for all manufacturers starting in fiscal year 2022. So that's pretty much a quick summary of what we were able to do. I got Tom in here in my office now with me, and Sharif's on the phone, and we'd be happy to answer any questions. The one thing I do want to preface is the policies that were implemented throughout this pandemic, particularly the policies related to capacity, or the fact that your business was forced to close, or the mask wearing, things of that nature. They all came down directly from the Department of Health. We have it in our guidance and in our frequently asked questions to make sure that our licensees are aware of what those obligations are. But we had very little to do and will have very little to do with implementing those policies, because they are being written and imposed based on consultations with medical professionals, and obviously none of us are that here at the SLA. So, but we'll be happy to answer any of your other questions.
Thank you, Chairman. I'm sure there's some questions out there. Stefan, did you have a few things you wanted to add before we round things up?
Just a couple of small updates that are mostly non-liquor authority related. First, Paul, I just want to also add my thanks to you and the Brewers Association for having us every year. Very sad we can't be in person today. This is one of the best conferences in the industry. But I'm happy to be providing everyone with the update today. And I just need to thank, again, as I do every year, Chairman Bradley, Tom Donahue, Sharif Kabir, Bill Crowley, Adam Roberts, and just the entire Liquor Authority. I could not do my job helping all of you without their diligence, knowledge, and expertise and assistance. If you've ever received help or information from me in the past, it's more than likely that they had a large part in getting you an answer. So thank you again to everyone from the Liquor Authority. Just a few updates I want to run through. This one I think most people are aware of, but if you are packaging and selling bottles and cans, you must be signed up with the New York State Department of Tax and Finance as a deposit initiator. You must collect 5 cents for every can and bottle sold, and you must file quarterly reports with the Department of Tax and Finance. The New York 5 cent must be on the top of the can and on the label. One of the updates for the COVID situation, I understand that there's a few brewers out there that did receive rather large fines for missing a payment, especially in the early part of the pandemic. If that did happen to you, please reach out to me and we can try to connect directly with the Department of Tax and Finance to hopefully remedy that. There was some really very large fines that were out there. So we'll see what maybe we can do about that. The TTB formula requirements, Paul, I'm not sure if you addressed this in any earlier sessions, but something that came out from one of the brewers during the pandemic was the Federal Tax and Trade Bureau started reaching out to some brewers about their formula not being filed with the TTB. If your beer contains any quote unquote non-traditional either ingredients or processes, you must first obtain formula approval from the TTB for making that beer before you make it, regardless of whether you're getting a cola or not. It doesn't really have anything to do with your certificate of label approval. Paul sent out an update, a weekly update on September 23rd of 2020, and I'm sure is available on the website, that had all of the relevant info and links. So make sure that if you have any non-traditional ingredients or processes for your beer, that you're getting a formula update with the TTB first. Something I always like to mention is the alcohol beverage production tax credit. The credit is equal to 14 cents per gallon on the first 500,000 gallons of beer, cider, wine, or liquor produced in the state in a tax year. So make sure that you are applying for that. You can apply for the rebate for up to 3 years after you filed your taxes. You do not need to pay sales tax on any raw food materials used in the manufacture of your beer. You do not need to pay sales tax on equipment you purchase to be used in the production of your beer as well. As I think most of you should know, hopefully you all know, Department of Tax and Finance rolled out their new electronic filing system for paying your excise tax this year. Please let me know if you have any questions or issues about that, or if you need to be connected directly with the department for that. The 20C license, here's another issue that popped up because of COVID related issues. The 20C license is a food processor's license from the Department of Ag and Markets. If you have a microbrewing license or a restaurant brewing license, you're required to have the 20C license. Though the brewers that have only the farm brewing license and no other manufacturing license do not need to, and no other farm manufacturing license, do not need to get the 20C license. Farm licensees are exempt from getting the 20C, but still need to follow all of the rules and regulations laid out in 20C. If you are, like I said, if you're a microbrewer, if you have the microbrewing license or have the restaurant brewing license, it's a 2-year, $400 license, and it is mandated by law. So make sure that you are staying on top of the 20C license. And then this is something also that just came up recently. Renewals for the liquor authority. Make sure you're setting your own reminders for renewals in Google Calendars or whatever you use to track your business. It's something that comes up every now and again. Mistakes can happen. Make sure you're staying on top of your renewals. You don't want to be finding out on the day that your license expires that you did not renew your license. So make sure you're doing that. And then the last thing that I have is that if you're going to be doing an expansion and are interested in New York State incentives, please reach out to me during the planning stages before you do any work, before you purchase any equipment or hire any employees. The current incentive options from Empire State Development are limited at this time due to COVID and the budget situation that we have right now. But more options could become available when Congress and the president pass the stimulus plan. If they pass the stimulus plan and New York State subsequently passes a budget, which is due on April 1st, we'll hopefully know more by then, but we won't know exactly what that looks like or what those incentives might be. So just something to keep in mind, but definitely always reach out to me prior to doing any work if you're going to be doing any sort of expansion. And those are all the updates I have for right now, Paul.
Great. We're starting to get some questions. And again, you put those in chat and I'll call you out. So I'm not sure who's on from Destination Unknown, but I'm sure this is for the authority. Go ahead and ask that question.
Hi, Paul. Yeah, we're just wondering if there can be some clarification on if licensees are able to operate a second tasting room while the approval is still in process, since you mentioned that it would be possible for a farm brewer to start operating while the approval is in process.
This is Sharif. I think what you're referring to is what Chairman Bradley had mentioned with regard to the proposal we had made in the budget, which has not yet been enacted. So we proposed last year, and the governor has now proposed this year, a temporary permit to allow operations in the pendency of license processing. That's not yet been enacted. So I think in all respects, the ability to exercise the privileges of a permit or a license come with final approval, if that answers your question.
Okay, thank you.
And hopefully that will be enacted by this April, and then it would come into effect in the fiscal year 2022.
Do you think that, and I missed the 2022 part, do you think it's something that could be enacted this year if we were to work it? I mean, is it something the authority could do quickly if we if we were able to get this, if possible, in 2021?
So it would be 2021. I'm sorry. The chairman said fiscal year 2022. So that's too much inside baseball, right? So fiscal year 2022 begins April 1 of 2021.
Yeah, sorry about that. That's my fault.
It gets me every time. So thank you for that. Yeah, because I keep thinking that. So good. That's good to know, because I know there's a lot of folks, and it's still about 6 months. Is that correct for wait times?
I actually have Adam here. I don't think it is quite 6 months, but do you know?
Yeah, for current processing times for temporary retail permits is actually about 30 days from the time that it's received by the authority.
No, he's talking about manufacturing license application.
The manufacturing license, yes, it's still about 24 to 26 weeks processing times.
24 to 26 weeks. Okay. Randy, you have your question?
Sure, Paul. Thank you. And thanks to the folks from SLA for joining us today. I think we're still operating under the rules that were spelled out in a Q&A page about music. No advertising, no cover fees, and no reservations. But this has been confusing because a lot of breweries continue to have music while others have basically shut down. We, for instance, have shut down music. So I'm wondering, looking forward, and really hopefully looking toward a summer when we can be outdoors and have bands, what the rules from the SLA, maybe you could define where we currently stand and what it would take to then reopen regular music at breweries with advertising and reservations and that sort of thing.
So I'll let Sharif handle this, since he actually had a lot to do with writing that guidance. But I do want to reiterate that this policy is coming from the Department of Health. All we're doing is putting it in a language you guys and we can understand. But this is not something that we're pulling the strings on. They are. But Sharif, do you want to handle that?
Yeah, so the current guidance continues to be from the Department of Health that live entertainment events are not permissible. What is permissible continues to be incidental music, which really is incidental to dining, which is permitted. As the chairman said, what will be permissible moving forward as restrictions ease, as the COVID situation gets better, we really couldn't speak to. I think that it's entirely possible that if things keep going in this direction, that you would see guidance in the coming weeks or months on what's going to be permissible in the warmer weather. But we don't really know what that's going to be. Currently, as I said, what's permissible really is just the incidental music.
Okay, thank you. I had a visit from one of your inspectors and about music, and we hadn't had music in 4 months, but it's inconsistent on, are you trying to find breweries that are currently having music? Because many of them are. They haven't stopped.
So, we generally operate on the basis of complaints. We have 70,000 licenses throughout the state, and we don't have the number of investigators that would allow us to get to every place. So we don't know what's happening everywhere at every time. If you're aware of places that you believe are not abiding by the COVID-related regulations and you want to let us know, or anybody wants to let us know, we have an anonymous form on our website under enforcement on the drop down on our homepage where you can let us know. We think that these regulations are important. The Department of Health tells us these regulations are important in stopping and slowing the spread of COVID. So, if we find out about it, we'll absolutely be there. And if we see it, there will absolutely be disciplinary charges.
So, and I didn't really touch upon in when I was speaking about the fact that we have an extremely enhanced enforcement operation going on right now, but because a lot of the issues that we were seeing when the restaurants reopened were down in the southern part of the state, we have a number of our investigators, along with investigators that we borrowed from other agencies, that are focusing on that area of the state, and some of it has been reported on in the press about how the number of establishments that we have visited, and in those instances we are doing it on a patrolling basis, but for most of the part, when you get north of the Tappan Zee Bridge, it's based on complaints.
Thank you.
Rich Steele, you had a question?
Yeah, thank you, Paul, and thank you to everybody at the SLA. My question has to do with the temporary alteration of premises, and having submitted for 2 different tap rooms. Customers enjoy the new facility or the new space, and we've certainly invested a fair amount of capital. So my question has to do, will there be a streamlined process to turn the temporary alteration of premises into a permanent alteration, or will we have to go to the kind of pre-COVID, pre-June rules of submitting all the necessary paperwork as it was previously done?
Sharif, I have Adam in here. I'll let him handle that one.
I mean, so at this point, the temporary alterations are allowed through, while the governor's executive orders are in place. For any alteration that people are seeking to make a permanent part of their license, would have to go through the normal alteration process at this time. To streamline the temporary alterations, the alterations themselves were kind of self-certified. We were taking people at their word as to what the alterations were with relation to it being in accordance to our guidance. So any alteration that would become a permanent part of the license would have to go through the standard alteration process and be vetted accordingly.
But to further what Adam just said, it sounds like you want to make this a permanent part of your establishment. You should just go ahead and file the alteration now.
Yeah, so there's nothing that, to Sharif's point, there's nothing that prohibits you from filing that alteration now. If it's space that you've invested capital or resources into and wish to make it a permanent part of your license, you can certainly apply for that alteration now. It's not exclusive to when that temporary program ends. So you can file that application at any point.
Okay.
That helps answer your question.
It does. Thank you very much.
And what would the timeline be for something like that?
It depends on what part of the state you're in and whether it's a substantial or minor alteration. So based on our law, it's broken down into categories of substantial and minor alterations. The latter minor alterations would still fall within the 24 to 26 weeks.
And the same with the branch office timeframe. If somebody, that question's in the chat as well.
Yeah, that's correct. Branch offices are still queued in that same timeline. We understand that a lot of the paperwork that people are submitting are generally the same as far as the main applicant license, but we don't have a separate queuing process for branch office locations.
Yeah, we're really hoping, the NYSBA, we had legislation written up to help with the temporary permit to kind of mirror what the wine industry has, and so we were fortunate enough that the governor actually put it in his budget, which we hope stays. So I don't see any reason why it would get kicked out, because we know a lot of you temporary permits are going to help a lot of folks open, and it'll certainly give a boost to the industry.
Yeah, and that temporary permit could obviously be used for the branch office as well once it gets passed.
Doug, you had a question?
Can I also just with regard to that, can I just also just let everybody know who is here. It's always helpful for legislators to hear from their constituents, but particularly their constituent businesses. when they support or oppose a proposal, but let's say support in this instance. And so, to the extent that this is something that, we have always viewed as very helpful to the industry, very helpful to you as business owners, it would be helpful if you reached out to your legislator and let them know that this is a proposal in the governor's budget that you strongly support and would like to see them help to move forward in the budget process so it doesn't get kicked out. I think Paul is right. I don't know that I expect it to, particularly under these economic conditions, but you really never know what's going to happen during the budget process, and the budget's really going to be the best vehicle to move this forward. So, any support for this proposal with your legislators would certainly be helpful.
Yeah, that's great input. Doug, go ahead.
Okay, me, Paul?
Yep.
Okay, so the 20C, it's the first I've heard that. What, if you have a combination license, is that also a requirement? If you have a farm license and a microbrew license?
Yeah,
Sounds
hi,
like,
Doug.
sounds like the microbrew license is it. You need it.
Yes, that is correct. And sorry, I tripped over my words a little bit there when I was describing that. If you only have a farm license, that's the only license you have, then you do not need the 20C. But if you have anything that is a non-farm license, then the 20C is required.
Okay.
It doesn't matter if there's a combination of 2 or 3 or 6. It doesn't matter however many there are. If you have a non-farm license, then the 20C is required.
Okay, definitely we'll look into that. Let me piggyback on the music question, since it looks like we might be able to have some weddings with 150 people or so. And we have a place to put a big tent, and we might be able to do that. Are they going to be under the same music requirements if they're on our property as we are?
Sharif, if you want to answer that, you wrote that as well.
Yeah, the music requirement is just going to flow through your license. So if you only have a manufacturing license, generally, if there are no restrictions on your license, then whatever form of music you would have would be permissible. If you have a separate on-premises license, it goes the other way. It's going to have to be a condition that's permissible on the license.
Okay.
And that all sort of presumes that the spot in which you are referring to is within the licensed premises.
Yeah, it is. It's a big,
Okay.
it's a big backyard, and we've been hit up with a tent there. It's very possible. But for weddings, receptions, and parties, and that kind of stuff, I'm just wondering if they want to have a band out there or something. Can they do it?
Yeah, there's specific guidance on that, how music can be offered and how a DJ could be offered in the revised food establishment guidance that will put in place the new guidance for large scale catered in-person events. So if you take a look at that, you should be able to see what the specific guidelines are. They tend to mimic what's already in the law, the 12-foot separation, et cetera, from patrons. But there is specific guidance on that matter in the Department of Health food establishment guidance.
DOH. Right, perfect. That's all I need. Thank you.
Sure.
We're going to have some more on Thursday on our members meeting. We do have a heads up that there's going to be some changes, significant changes by March 15th that we'll explain on the members meeting on Thursday. But I accidentally skipped over Bill. Bill, I'm sorry. Go ahead and ask your question. It's an important one.
Thank you, Paul. First, I'd like to thank the SLA for jumping through a lot of hoops to get us open and get us documentation in real quick order. My question is, we have an account that is terminally late in paying their bills. Usually it needed a reminder. Then when they decided to stop carrying us, they did not pay their last bill. So I went into the delinquency website to flag them, and I could not find their license. So when I reached out to the SLA, there was something in a statute that did not require a manufacturer to get flagged as delinquent. Can you talk about that? If that makes sense.
Chairman, is Tom still there? He could probably give the
Yeah,
best
yeah,
answer.
Tom, we're gonna have to dig deep into Tom's brain for this one.
All right, so you're selling product to another manufacturer who's selling the product at retail.
They are selling it in their tasting room.
So under the terms of sale provisions, that only governs the relationship between wholesalers and manufacturers on one end and retail licensees on the other. So if they're buying it under the manufacturing license, they're not covered by the COD provisions. So your only remedy would be, what any licensee has, would be to sue them for the money.
That answer your question, Bill?
Yeah, it does. And unfortunately, the guy we sell it to is a lawyer.
Sorry.
Thank you.
John Anthony, go ahead.
Hey guys, as with everybody, thank you to all the members of the SLA. We really appreciate you guys working so closely with us, and Stefan and Paul are a huge resource as like a conduit. So sometimes we just go through them and we get answers back. It's been great, and everything during the beginning of the pandemic was so helpful. And one of the most helpful thing was for shipping for us. So my question was, my understanding is that the SLA is okay. We just had to find the UPS or FedEx portion to facilitate the direct-to-consumer shipping. Am I correct with that? So as long as UPS or FedEx agrees to do direct shipping, it's going to stay post-pandemic.
Well, there's two issues there. One, if you have an on-premise licensee license at your manufacturer, meaning a restaurant, in addition to your, or a bar or tavern, in addition to your tasting room, you have a right and have always had a right to ship beer as a result of that license. And bars and restaurants have the right to do that as well, ship beer within the state. And whoever's shipping it for you is obviously required to also have the proper permit in order to do that. And that's what's being allowed right now. As far as the shipping, if you're not a licensed OP, that's something that I know Paul has been working on over the last couple of years, and that's a more complex question and does require legislation. So it's not really something that would continue without that legislation. Is that a question?
Thank you. I appreciate that.
We tomorrow, and I did it a few weeks ago in my normal Wednesday blast, that we do have a direct-to-consumer survey that we need everybody to fill out, find out who wants it, whether it's something that we need to do legislatively. But as the chairman said, if you do have an OP with the rest of your licenses, it can continue after the executive orders. And I think I found it sort of interesting, and I don't know if anybody at the SLA can answer this, that usually the executive orders have been every 30 days. And so the last one ended at the end of February, and this one, I see that it's March 16th that that it expires. And I'm not sure why it wasn't added throughout the entire month of March.
Sharif, do you? I don't know the answer to that. Sharif, do you?
I really don't know. I'd have to guess it was a matter of convenience. I know they extended through March 16th, so I assume, I didn't look at what date that was, but I would imagine they did it on February 16th to take them through to the next 30-day period. I'm not sure what happened in the interim, or I think what they did was they did less than 30 days on the last extender and then went 30 days on this one. But again, I think it was probably just a matter of convenience, or it may have been a matter of syncing up some dates.
Okay. Yeah, I know there's a lot of nerves right now going on with everything that's going on with the governor and, the legislature, some in the legislature wanting to remove his executive powers. So I know that the NYSBA is talking to legislators in the background just to kind of let them all know that if they do this or are successful in doing this, that there are regulations like this, temporary regulations that are allowing a lot of you to stay open and to consider that. So they are, and so those conversations are continuing. in the background as well. So Chairman, I have a question for you all at the SLA as well, which I was getting early on when an investigator, how the investigative process works. If somebody goes into a brewery and sees a violation, do they ever announce themselves? A lot of times I'm hearing that they'll get, some people get a fine. Like one brewery said they had a fine like a month and a half after the violation. What's the normal process, I guess, for brewers?
So pre-COVID, I guess the answer is it would depend. If pre-COVID, it would be the way the process worked pre-COVID. No matter what was going on, particularly at breweries, we would not end up in a brewery unless we got a complaint either from the public or from local law enforcement. We didn't, we don't go around picking random licensees at that time to go visit and do inspections on. And I guess at the time that, pre-COVID, it would depend on what the violations were. If it was a situation where we were doing an inspection with local law enforcement, then yeah, we would identify ourselves. If it was a situation where they sent an underage person in, more than likely you would not hear about the fact that you sold to an underage person, at least for until the charge came out. And what we've tried to do is send correspondence as quickly as possible so they know that they did sell to an underage person and that there's charges coming. During COVID, once again, it depends. What we're doing now, our investigators, even in response to complaints, is really just looking at violations of the executive orders. We're not going around doing underage sales. We're not, and I can't speak for law enforcement because I have seen that they've done their own underage sales during this time, but we're as an agency not doing it. All we're doing is enforcement of the executive orders, and it really depends on what executive order we see the investigator sees has been violated. If it's a situation where they're over capacity, most of the time they are going to identify themselves and tell them that there is a violation here, and we actually have letters that we've been handing out. But on some instances it doesn't happen. But like I said, I know in the southern part of the state, almost 100% of the time now they are identifying themselves. But Sharif, do you have anything as far as the complaints go? What's happening?
I'm sorry, in terms of complaints of what?
As far as the complaints, when we get complaints upstate or related to the executive orders, are the investigators identifying themselves, or is it depend on what the violation is still?
No, it's two things, right? As you said, it would very much depend on the circumstances. Sometimes it makes sense for them to remain undisclosed for a number of reasons. Sometimes it doesn't. But generally what they would do in any circumstance is either they would disclose themselves at the point in time and they would let them know what the observed violations were. If for whatever reason they wanted to remain undisclosed, generally what they should be doing is upon leaving the premises, they should be contacting the owner, manager, principal, and letting them know that they observed a violation. I mean, the reason being, I think what you're suggesting, we don't want the violation to be a surprise, and we don't want the potentially non-compliant behavior to continue in the interim. So the process should be that either they would be aware on the spot or that they would be aware immediately after. If that hasn't happened on occasion, then that's a failing in our process. But certainly from a process perspective, as I said, our chief goal, particularly with regard to the COVID regulations, is to see compliance for public health reasons.
And just to build on that, during the period of time that we've been doing this enhanced enforcement, I actually during the summer was out a lot myself in New York City doing it in bars and restaurants, and I was with a couple of other investigators, and we identified ourselves 100% of the time, and I probably went into several hundred establishments. But to put it in perspective, we are, since the time that started, which was July 23rd, was when we started our enhanced enforcement, we've done summary suspensions on over 400 licensees. So that's, a little over 8 months. And in a normal year, without COVID, we usually do between 25 and 30. Now, you'll all be happy to know that during the period of time of that enhanced enforcement, we have not done one summary suspension on a brewer. We did do one summary suspension in May in Hudson, New York. That was before the enhanced enforcement, and I believe that was for executive order violations. But your group has been extremely compliant since this has all, since you've all been allowed to reopen. So that's very good to see.
Well, and I know, I mean, obviously I'm biased, but I know how hard they're all working too to be compliant. And a lot of them, if they're not compliant, it's either because they either misunderstood the, things, or, they're not intentionally trying to be non-compliant. But what are some of the most common violations that you all are seeing that are easily correctable? Is there one or two that stand out?
Oh yeah, the biggest, and it was almost in 100% of the places I visited myself, is the employees not wearing masks. And I understand how I want to get the thing off my face as quickly as possible myself when I'm out. And I understand, particularly if you're working in a kitchen or somewhere like that, how uncomfortable it is. But pretty much we walk in places and you'll see it on the bartender's chin, or they're not wearing it. That's by far the most common violation, without question. A lot of the other violations were indoor service when it wasn't allowed. Obviously, for all of the state right now, it is allowed. But when we were seeing indoor service when it was only supposed to be outdoors, that was a big issue, but it's obviously been less now. And then recently we've seen a lot of overcrowding, but not necessarily in breweries, because generally breweries have a lot of space, but certainly in restaurants in the southern part of the state.
So if a brewery does get fined, and again, please, you guys, we have about 8 or 9 minutes left. If you have any final questions, entering them in chat. Now is the time that we have them. Let's say somebody gets a fine mailed to them and they feel that it's unjust, or feels that it's unfair, or that they just dispute it. Is there a process they can go through to?
Yes, you get, the charge would come to you in what's called a notice of pleading. It's mailed to the licensee at the licensed premise, as well as to the residents. And it has a listed charges on it. And then it has instructions that if they want to plead not guilty, they can go through a process that leads to a hearing in front of an administrative law judge. If they're also, I believe at this point, 100% of the time offered a deal, which is called a conditional no contest, which has a fine amount. For first offenses on these EO violations, it's generally been $1,500 if you have no history for your first offense. And that could be, you could end up with 3 charges on that date. It would still be $1,500 would be the max fine. Now your second time, that obviously goes up incrementally. And if they want, or they can just plead straight no contest, which means that they are putting the fine on the board, and the board would determine what that fine is at the time that it comes. You're also obviously allowed to put in any mitigating circumstances through writing at this point. We usually have live board hearings, but during COVID, everything is on video, and we're not taking any public comment. So the public comment has to come in through written materials, but they obviously could submit any of that. Or as I said, they could go to hearing, where they will have a hearing. Right now, we're doing that process on video as well, and they will be able to call witnesses, cross-examine witnesses, and handle it that way if they feel like it was if they're innocent of the charge.
Randy, we've got a couple more questions. Randy?
Yeah, one of the late executive orders was a requirement for food. And as people look to reopen on site, is there still that food requirement, which for manufacturers was interpreted, it could be snacks, crackers, chips, that kind of stuff, but for bars and restaurants was more substantial food. Do we still have that requirement?
You still do have it, yes. That once again is something that's coming directly from the governor and the Department of Health. I couldn't predict how long that will go on. I have to believe it would go on through the summer, though, just personally. But We're not involved in those conversations. We just enforce it.
Okay, thank you.
Ann Riley, who is the Executive Director of the New York City Brewers Guild. Ann, go ahead with your question.
Sure, Commissioner, thank you so much for taking the time with all of us. Really appreciate it. Luckily, our breweries have worked very hard to remain compliant on all aspects, but I know that this is regularly a concern for many of our supporting restaurants, bars, and shops. The New York City Office of Nightlife regularly states to them that they work as a mediator for places that have been given a violation. Are they regularly working with you in your offices?
That I couldn't speak to. I haven't really met with Ariel in quite some time, but they so to my knowledge, no. But Sharif, are you aware of that?
No, I mean, certainly we do speak to Ariel, as the chairman said, but not generally with respect to any particular disciplinary issues. We wouldn't really have conversations with regard to particular disciplinary issues outside of the licensee themselves and or their representatives.
Yeah, I myself am not really permitted to have any conversations with the licensee either, since I'm one of the 3 people that decides what the punishment or penalty is. So that would not happen with me at all. It would have to go through Sharif. And like I said, we haven't really had a lot of conversations with her since this has been going on.
Okay, thank you. I appreciate the input.
All right, last call for questions before we wrap it up. Anyone else? No, nobody's wrestling with mute right now. All right, well, if not, I want to really, again, thank you, Chairman Bradley. Thank you, Tom. Thank you, Sharif. Thank you, Adam, for chiming in the background, and Stefan for being on this. I know a lot of people relied on the NYSBA's, at the beginning of this, especially our daily correspondence, and I couldn't have gotten you a lot of that without Sharif or Chairman or Tom or somebody picking up the phone or Stefan giving me the information to get to you. So again, thank you to the SLA for being so responsive to us, because you really helped everybody on this call and beyond, and it really saved a lot of folks. So thank you for your time today. And we look forward to seeing you in person soon.
Yeah, me too. And I just want to thank you for having us. As I said, it's just based on the questions we get asked. It gives us a lot of information moving forward for us. And we obviously would love to hear from any of you directly. You can certainly email me or Sharif or Adam directly, or we also have a licensing info box that you're welcome to ask questions to. But the way that changes have been made in this industry is from hearing from the industry. So that's always been important. And that's why it's great to have the relationship we have with you guys. And hopefully next year we can do this in person, because it is as Stefan said before, it's the favorite one I go to as well. So
maybe we can get you to hand out the Governor's Cup again. So
okay.
and yes, and Stefan's also a great resource as well as our one-stop shop. So thank you, everybody. Have a great Tuesday, and we appreciate you being here.